We continue with the lecture series for Practical Law Office Management, Chapter 3, Ethics and Malpractice by Cynthia Train-Adonis. This is the fourth of the five-part series, and in this piece of the series, we're going to cover conflicts of interest. I apologize if I am talking a little bit fast. I have a meeting in like 15 minutes, but that's about as long as I like these to last. So just, like I said, I do apologize if I'm moving too fast. It's been a difficult day to get to things. I keep getting interrupted. Anyway, objectives. We're going to cover these two objectives that are highlighted, explaining what a conflict of interest is, what a law office can do to limit conflict of interest problems, and discuss what an ethical wall is and when it applies. A conflict of interest occurs when an attorney or a paralegal has a competing personal or professional interest or interests with a client's case, and that would preclude him or her from acting impartially for the client, toward the client. Conflict of interest problems tend to occur when an attorney or paralegal has a personal, financial, or other interest in a case, or the attorney or paralegal is a substantial witness in the case, or the attorney or paralegal sometime in the past represented a client who is now an adverse party in a current case, or an attorney and a client enter into a business together. The conflict of interest problems occur also when the attorney is asked to advocate a position on behalf of a client that is contrary to the position of another of the firm's clients, and this we call an issue conflict, or a law firm merges with another, or it is acquired by another. And it also generally happens when legal professionals change job firms. So I have some suggestions, some information on that coming soon. So how do we avoid conflicts? Conflict checking. That is an initial step after when a client is interested in hiring a law firm. It should be done whenever a new case is accepted, and it should ensure that the law office does not have a potential conflict with the case the law office is getting ready to accept. On page, Exhibit 3-11 in the textbook, that is on page 137 of the current edition of the book, there is a list of items to track in a conflict database. Also realize that checking conflicts is important, and many ethical pieces are important, because insurance companies write professional malpractice insurance for attorneys, and they often dictate in their policy, insurance policy that is, what is required of attorneys in order to maintain their insurance, and one of them may be very well be checking for conflicts. So if there is an ethical conflict, what do we do? How do we resolve that? Well, the general rule is that courts tend to disqualify a whole firm when a conflict of interest problem arises. For example, there's a law firm and one lawyer or one paralegal, I want to just say lawyer, but one lawyer has worked for the client in the past, or there's a conflict like one of those listed prior. And in that case, they will disqualify the whole firm. In Florida, the court rules have carved out an alternative to disqualifying the entire firm, and that's called the ethical wall. The book uses the term Chinese wall. I do not use that term anymore. It's a pretty old term, and I think if you did a little Google search on it, you would kind of understand why it isn't really a culturally acceptable thing to say anymore. So they put in this ethical wall around the person with the conflict. Effectively, the firm isolates the paralegal or attorney with a conflict of interest from having anything whatsoever to do with the case, and that creates an ethical wall around him or her. It's put in place by instructing staff members not to talk to the person who has the conflict about the case, limiting the person's access to electronic files and paper files of the case, so they would not have any access to it. I did a little search on Google. I found this interesting article that you might want to read. It is ethical issues involved in leaving a law firm. And it goes through what the Florida bar says, and it's really quite recent, May of 2019. As of right now, that's not really that old of an article. So they call this ethical pitfalls in Florida changing firms. The Florida bar's ethics hotline, the article states, they get a lot of questions about what do I do if I want to change jobs, noting that today people don't typically stay at their job for 40 years. Most particularly, partners, of course, of law firms. We talked about that in Chapter 1. They might be staying there a long time, but a lot of attorneys are mobile. A lot of paralegals are mobile. And so they get these calls, and they've responded to it with this ethics article. So in the interview process, it's frequent in Florida that the interviewee, the person applying for the work, is asked to provide a list of clients to determine both the business that a lawyer can bring, and also for the purpose of identifying conflicts to see if an ethical wall is needed. Subsection C6 of Rule 4-1.6 of the rules regulating the Florida bar address this issue. Confidential information is privileged information regardless of the source, and that includes clients' names, unless there is informed consent from the clients. Well, you're being asked to give confidential information to another law firm. It's no different than giving client names to anybody. It's like, well, I'm already in a place where I'm not supposed to be sharing this information. But what has happened is subsection C6 provides an exception that allows a lawyer to reveal information to detect and resolve conflicts of interest when a lawyer is changing firms. If the information is not if the information shared does not adversely affect the client. Subsection F of Rule 4-1.6 also limits the disclosure to only what is necessary to accomplish the purposes of the rule. So the client list might be supplied without much detail, just names maybe to start with, and then graduating toward more information, but then of course having that limit of disclosing what is necessary to accomplish the purposes of the rule. And that would be it. Here's a copy of the rule from the Rule 4-1.6 from the Rules of Professional Conduct, Florida. Follows rules regulating the Florida bar, and what I just outlined in a little capsule in the previous slide is what this is saying. But give you an idea of what it has in its entirety if you want to read it. All right, so how do paralegals? They avoid conflicts of interest when they change jobs in the same way, bringing up the issue of potential conflicts in the job interview. Typically, the paralegal's resume is going to say where they've been working prior, and that's a initial outlook of, wow, we've got some cases where they're opposing counsel, and we need to look more deeply into what cases this particular paralegal's worked on. So they might provide a list through, of course, their attorney, the law firm that they were working for. That would have to be something the paralegal really should not be responsible for that piece. If he or she is moving to a new firm, the attorneys will probably resolve this. But being honest about the past experiences is important. And then sometimes conflicts come up when you're not expecting them. There's already working for a law firm. People are generally paying attention to the attorneys and their conflict, and a paralegal situation might kind of get slip through the cracks and not be realized. So if a paralegal is working at a firm and realizes a conflict has occurred or may be possible, it's time to tell a supervising attorney or the human resources office that there is a potential conflict. So how do we do conflict checking? First of all, a written policy regarding the conflict checking is really important. But it's generally a simple process. Firms maintain a list of clients and adverse parties, and they consult the list when a potential client reaches out to a firm, and before retaining the firm, they would check that conflict list. Computer programs are used for this a lot, typically a database type of program, but other areas of technology can fold into being useful for conflict checking, like an accounting program, billing program, docket control, or case management program. Exhibit 311, 3-11, I mentioned it earlier on page 137, illustrates the different conflict of interest designs. And this will depend on the type of work the firm specializes in. You know, for example, it's not just about the adverse party to a case. It can be also people that were witnesses, investigators involved. If you're in bankruptcy, for example, it could be both debtors and creditors that might create a conflict of interest, depending on what side you were on in the pending case or prior case. There could be other interested parties, experts, heirs of an estate or trust that was disputed, and they also are looking a little more deeply than that too, to some kind of nexus. A conflict isn't just a conflict because somebody comes in the door and says, I used to work for another law firm. They're going to look at the type of case. I'm going to expand that a little bit more as they start to develop what looks like it could be a conflict by name only or by action only. All right, so it's a little bit more. There's more complexity to the conflict resolution, the conflict checking piece. But on a general level, the book outlines, these points here that are quite typical as the first entry-level threshold step. All right. So I told you that would be quick. I apologize if I did talk too fast. I hope you have a wonderful day, and thank you for your time.